moment in the evolution of dispute resolution, as we stand in the brink of a new era where digital innovation transforms every touch point of our professional lives. And we gather here to navigate the future of cross-border commerce and dispute resolution in the digital age. So let's cast our mind back for a decade, for a moment, where the landscape of arbitration was quite different. And Pui-ki will remember when we used to work together at the ICC Secretariat in Paris, where it was still quite old-fashioned. That lawyers will send their associate with suitcase of files just from London to Paris just to file it on time. And in our team, we have actually a full-time case manager whose job is like punching holes, putting files together in those piles of folders of arbitration cases. And that was only a decade ago. But today, imagine a world where the once laborious tasks of lawyers and arbitrators were radically transformed with the advent of technology. And imagine for a moment where legal documents are being prepared with assistance of AI, predictive analytics, offering insights into possible outcomes of arbitration, and the once unthinkable notion of robot arbitrators rendering decisions. And this is not even in the distant future. It's a reality that we are stepping into today, where the keystone of our devices carry the weight of the gravels in the courtrooms. So as we delve into discussions, let's challenge ourselves to think beyond the constraints of traditional dispute resolution, to embrace the potential of technology in forging pathways to justice, and to consider the profound implications of our digital evolution on international commerce, as well as the challenges that it brings to the concept of justice, due process, equality of parties, privacy, digital protection, data protection, etc. So we stand at the cusp of evolution that redefines the very fabric of arbitration and dispute resolution. So let's embark on this journey together with our distinguished panel speakers who are really at the forefront of this transformation. They represent the vibrant nexus of Australian and Chinese commerce and legal innovation, embodying the spirit of collaboration and forward thinking, which is necessary to thrive in the digital frontier of dispute resolution. So in our session, our speakers will give us first an overview of dispute resolution in the digital environment in China and Australia respectively. And then we'll also hear from institutional perspective on how to navigate the challenges and strategies for resolving cross-border digital trade dispute. We'll hear first from each speaker who will present around 15 minutes, and we'll have about 20 minutes or so for Q&A. So I will, they all have a very impressive CV, so I will just briefly introduce the speaker in the order they will speak, and you can look at their full CV on the program. So our first speaker is Ms. Lu Fei, who will be joining us online. Lu Fei is the Director of Business Development Division of the China International Economic Trade and Arbitration Commission, CIETAC, responsible for business development initiative and international cooperation for organizations. Ms. Lu has 2 decades of experience at the CIETAC. She has joined CIETAC since 2003 as a case manager and has administered and supervised over 1,000 cases, both domestic and international. She also has a lot of experience acting as an arbitrator for various kinds of dispute. And she's a member of the editorial committee of arbitration and the law, which is the earliest professional law review on arbitration in mainland China. And she's also the driving force of the CIETAC Cup, which was the first time actually I encountered arbitration, and that shapes really the future generation of arbitration practitioners in China. So we're very glad that Lu Fei is able to join us today, and she will give us an overview of dispute resolution in the digital environment in China. So Lu Fei, the floor is yours.
Well, thank you, Kun. Can you hear me?
We can hear you.
Okay. Yeah, thank you, and I would like to thank CIBO for having me today to join this very interesting discussion. Well, yes, digitalization or digital economy has been a very hot topic for the past few years, because it's has been embedded in our life. For example, the theme of the China Arbitration Summit, which is the flagship event of the China arbitration community, last year was the digital development of arbitration. So today, I'm assigned with the topic of review of dispute resolution in the digital environment in China. I understand it's a rather broad and general topic, so probably I will just speak a little bit of everything to give you sort of a picture of what's going on in China. Of course, when we talk about the dispute resolution of digital related issues, we cannot avoid discussing, first of all, the status quo or development of the digital economy of China. Next page, please. Next. Probably we still have to go on with the next page, because I will present you some figures and data. So I asked my colleagues to help me prepare these slides. In the process, I probably will deviate a little bit from it, either by omitting or adding something. But generally, I would like to, through these slides, to give you some, for the sake of understanding. That for the chart on this page, you probably could see that the current development status of the digital economy in China. According to the research report released at the main forum of the Global Digital Economy Conference last year, well, China's digital economy increased by $4.1 trillion. And the scale of China's digital economy grew to 50.2 trillion yuan. That's about $6 trillion in 2022. And the share of the digital economy in the country's GDP has risen to 41.5%. So you can see that it's very important that the digital economy has been one of important sector in the Chinese economy. Next page, please. Besides that, China has unveiled a plan to promote the digital development. That's called the Digital China Plan. So by 2025, we plan to have effective interconnectivity in digital infrastructure and significantly improve the digital economy. And also, we plan to make major breakthroughs in digital technology innovation. So a system for the independent digital technology innovation will be built, and the business will be encouraged to play leading role in technological innovation according to the plan. We could foresee how developed the digital market will be in China in the next few years. Next page, please. Well, another measure I think is important is China has established a data bureau under the National Development and Reform Commission, NDRC. If you know this organization, it's one of the most important powerful organ in China, in Chinese government. So the main function of the data bureau will to advance the development of data-related fundamental institutions, coordinate the integration and development and application of data resources, and primarily to push forward the plan of the digital China. So that's about the overview of what is going on in the digital development in China. However, if today we are talking about dispute resolution, we should cast our eyes also to the problems that will be will arise from the development of the digital market. For example, there could be some suspect of monopolies of the market, and like infringement of privacies and concern about the data securities, etc. So China has made some stress to strengthen the legal framework in relation to the digital development. So next page, please. Next. I think it's wrongly placed. Please first go to the next page and later we'll come back. Yes, from the slide you can see there are a few very important laws promulgated recently in recent years in China. The new anti-monopoly guidelines, the data security law, personal information protection law, data security law, and the cybersecurity law, and more recently, the administrative provisions on mobile internet application information services. So those newly promulgated or advised laws actually showcased the resolution of the Chinese government to safeguard or to guarantee the sound development and running of the digital market. However, the passing of those legislation cannot avoid the rising of disputes. There are still many disputes inevitably arising from the digital economy. Frankly speaking, for CIETAC, we do not categorize our cases either by like digital related or not. But still on the top of our cases, it's sales contract disputes. And I believe many of them actually nowadays are related to e-commerce as well. And there we can see an increase of intellectual property disputes in our caseload. But to give you a sort of a direct idea of the types of dispute, I actually quoted some figures or some reports from the Hangzhou Internet Court. So can we go back to the previous page? Because Hangzhou Internet Court, first is the first Internet Court in China, and second, it's located in Hangzhou. That's one of the most important cities in the field of digital market in China. That's also the city where Alibaba locates. So according to the report of the Hangzhou Internet Court, most of their cases are e-commerce related. And among those cases, there are basically 5 categories: sales contract, product liability, agency service, network services, intellectual property disputes. So among the 5 categories, well, network service actually accounts for the most, accounting for like 45% of the whole cases, and sales contract comes second, accounting for 40%. So we can see primarily the composition of the case types accepted or by the law court. I think it could mirror somewhat the case types of arbitration as well. Next page, please. Yeah, thank you. Well, actually, for courts at upper level, we can see some measures well taken in responding to the development of the digital economy as well. Well, of course, we cannot understand as solely to respond to such development. However, it must be very closely related. Here, the one-stop diversified system by the Supreme People's Court of China, which connects actually mediation, litigation, arbitration on the same platform. What I would like to emphasize is they have established an online platform for this one-stop mechanism so that the parties can actually generate, send, receives, documents and the case status well on this platform. So this is what we can see from up to down the court system has, the efforts the court system has made in responding to the development of the data environment. However, well, I would like to say, I think many of you would agree with me, to resolve those data-related disputes, arbitration is a mechanism that's much more preferred than the court system. Next page, please. Because first of all, I think for the previous panels, many have talked about technologies. For national law courts judges, I believe them, not many of them know a lot about technologies. However, we have experts in the industry, which can serve as arbitrators and to hear the case. So, and also for data-related disputes, usually it requires very quick resolution of it, and the efficiency, of course, is a very obvious merits of arbitration, not to mention the wide enforceability of arbitral awards, which will be very useful for the cross-border e-commerce transactions. So next page, please. So I'm very optimistic about the future development of the digital dispute resolution by way of arbitration. And CIETAC actually has done some, I would say, we have taken some measures actually to cope with the potential of such big development. First of all, we have made some preparation of technologies. Next page, please. So the technologies first include an online filing system. Kun actually mentioned that in the traditional way that the parties would carry big files of documents to the institution. I would still say that it's still the case now before CIETAC arbitration, because now there exists I would say two ways of practice of the document production. One is the traditional way, and the other is the online. Our online filing system actually was put into use in 2018. Well, at first it was only developed to the PC side, but nowadays the mobile side has been developed simultaneously, especially via WeChat. If you know WeChat, it's an application that has been embedded in the everyday life of almost each Chinese people, and also being frequently used by people who have connections with China. So by this online filing system, the parties can upload their applications, or they can, by filling some information, and make the system to generate an application for arbitration. And then a case manager will be assigned to review their application and give feedbacks on this system. The parties can check the status of the progress at any time, either on PC side or on mobile side. So that's very convenient for the parties. We can see, although still some of the parties prefer the very traditional way of, filing the cases from the year 2020 to 2023, nearly 5,000 cases were filed online. Especially last year, we have 1,804 cases filed online. That's about 1/3 of our total caseload for the 1 year. Next page, please. Besides the online filing system, we actually developed also an intelligent hearing platform. So this is a tailor-made platform for arbitration hearings. It's unlike, the commercial conference apps. It will, I think, somewhat address the concern of the parties about the data security and the privacy. Because for this platform, each party or each participant of the hearing, either arbitrator or the witness or the attorney, will be assigned an account and a password, which will serve as their ID in the hearing platform. Then if they themselves do not release this ID to others, no one else can log in and enter this hearing system. And during the process of the hearing, well, there are also a facial recognition function by the system, so as to help the case manager or tribunal to identify the participants of the hearings. There are also some very interesting, I would say, small but useful functions. For example, the stenographers who are making transcript of the hearing can upload their transcript real time on the screen. And the parties can, on one hand, reviewing the transcript and making and editing it simultaneously. Also, they could sign through this system the record of the hearing. You probably know that the combination of mediation and arbitration is a practice very popular in China, and it is also the case with CIETAC. So for some of our cases, the parties can reach a settlement agreement in the process of a hearing, and then this platform can provide them with very convenient tool to sign through this system the settlement agreement on the spot. So while sometimes when people think give a second thought, they probably will change their mind. On the spot during the hearing, when they have the intention to settle, and you provide them convenient to sign, usually, well, the settlement is reached, and then a consent award is made based on it. So that will to facilitate the increase of the efficiency of the arbitration processes. And we also actually have some other systems being developed. We call it CIETAC ODR system. And for that system, all the process, all the proceedings, each link of the proceedings can be achieved on that platform. And the case managers, the tribunal members, as well as the parties and attorneys can communicate and check the status of the progress of the cases through that ODR. The reason that I did not put it on the slide because it's still on test run. So far, we have over 800 cases on test run on that platform, and we are receiving feedbacks from the users and to optimize the system. Next page, please. And next page, I will just omit it. Yeah, other than the technological tools, I think there are some, legal basis we have to provide for the use of the electronic means. You can see we have made some amendment for new arbitration rules 2024, either by expressly specify the use of electronic means or to prioritize the use of it. And the reason, I think, I could share you some like background information because, we actually had a lot of online hearings during the pandemic, even when the pandemic first broke out, because luckily we had the hearing platform developed at the beginning of the COVID. So the caseload of CIETAC was not affected even in the year 2019 and 2020. We witnessed an increase, and continuous increase for the past few years. However, some parties, especially the losing party, who have gone through the online hearing and they challenged the award before the court, saying that it's not in line with the arbitration rules, because in arbitration rules, people are expected to have a hearing, and they regard it as like a tangible hearing in person. And the court was, uncertain at the very beginning, and they had some communication with us, and they read our rules carefully. And later, they found that the challenge was not sustained because, according to the old version of CIETAC rules, there was a sentence like, the tribunal member can conduct the hearing in a way they think appropriate. So I would say that the courts in China are still in a very pro-arbitration attitude. So they choose to support, the use of online hearing. However, to avoid such things to happen again, we expressly specified in our rules, for example, Article 8, that arbitration documents first can be served in electronic form and should be prioritized. Of course, there are still, people or even attorneys preferring the hard copies and the, I would say, the real signatures. However, it's in our rules, and we encourage, it's sort of like a gesture or attitude showing to the users that the electronic form, electronic means of transformation is preferred. And also Article 21, parties can submit documents in electronic form in a preferred means. And online case filing, electronic signature, and even the electronic form of arbitral award, the status or effectiveness of them are recognized by the new rules. So we can see we not only prepared technologically, we also provide some like rule basis for the use of the technologies. Next page, please. Well, yeah, there are some other work that CIETAC being involved in relation to the digital issues. For example, the ODR system that is conducted by the APAC. It is a mechanism for the quick resolution of B2B cross-border disputes, and CIETAC was recommended as one of the first Chinese ODR service providers under this framework. Next page, please. And also, like I mentioned earlier, there is an increase of intellectual property, and I believe many of them are in relation to the development of the digital economy. So in the year 2022, we established an IP arbitration center, this to leverage the advantage of arbitration in resolving international commercial disputes and play an important part in meeting the market for those IP disputes. Next page, please. Well, traditionally, CIETAC has been dealing with, I would say, online disputes or digital-related disputes. That's domain name disputes. You can see that's the progress, the development of our domain name centers. The first, we only deal with like .cn disputes. Then gradually, we began to resolve some disputes involving generic top-level domains. And now, so it has been chosen to the CIETAC Online Dispute Resolution Center concurrently. Well, I think that's generally the introduction of what's going on of the digital-related disputes in China and the measures taken by the Chinese courts as well as especially CIETAC. I understand there are a lot of aspects about the digital-related disputes, and I believe there will be many new issues emerging. However, I would say a conference like this will, to communicate, exchange experience will be very useful for us to tackle with the future challenges and the unknown, potentials of the digital disputes. Well, thank you. I think that's the end of my presentation.
Thank you, Lu Fei, for such a fascinating overview of China's digital economy and its intersection with dispute resolution mechanisms. I think this development not only caters to the needs of China's digital economy, but also shows how legal framework can evolve to address the complexities of digital commerce. So I'm sure we have more questions about that. We might come back to that later. And now I would like to move to our next speaker, Ms. Edwina Kwan. And she's a partner at Kiran Wood Mallesons, who is generally supporting us, providing with a venue, and she focuses on regional Asian cross-border dispute resolution. Edwina has extensive experience in international arbitration, commercial dispute resolution, private and public international law, risk management, etc. And she has acted as counsel advocate in arbitration in all major global arbitration institutions and has advised private clients, government, SOEs, and their international legal obligations across a range of different sectors. She has been recognized for her expertise in who's legal international arbitration, Legal 500, Deutsch Leading Arbitration Lawyers Australia. She also is a co-founder of China Young Arbitration Group in Beijing and has lectured in Tsinghua UNSW Chartered Institute of Arbitrators. So we're very glad that she is with us today, and she will give us an overview of dispute resolution in the digital environment from Australia's perspective.
Thanks, Fan, and thanks everyone for having me to speak today. I am an Australian and a Hong Kong lawyer based here in Sydney, but I do a lot of cross-border disputes work involving both Asian, Chinese parties and Australian parties. And I think the interesting thing that I've seen in terms of digital trade and dispute resolution over the last few years is that not only are the types of cases that we're seeing evolving and changing in accordance with technology, we're seeing a lot more e-commerce disputes, tech disputes, crypto disputes, etc., but also the way in which those disputes are conducted. And so Lu Fei mentioned a number of technologies we're seeing that are being utilised in both the courts and in arbitration. I should know much more about digital trade than I do because my husband worked at Alibaba and at Financial for a long time and now is heading up a crypto exchange. But I'll be honest, my knowledge is limited to the disputes that I've been involved in. I think in terms of Australia, which is what I've been asked to talk about today, I'm going to talk a bit about challenges in resolving these digital trade disputes, in particular cross-border digital trade disputes from an Australian perspective. I'm going to talk a little bit about online dispute resolution and technologies like AI and blockchain and how they can be used effectively in dispute resolution. And then I'm going to talk a little bit about international trends and expectations for the future. I don't have any slides, apologies, but particularly for people online, but I'm hoping there's a lot to talk about, and any questions, just let us know. So look, in terms of the challenges for resolving cross-border digital trade disputes, particularly between China and Australia, I think even though the subject matter of these disputes and the way in which these disputes are conducted has evolved and changed in accordance with technology, I think that the key challenges remain for both non-digital trade disputes and other trade disputes. So obviously there's all the typical things you'd expect, like the cultural differences, technical expertise, governance and jurisdictional governing law issues. So I've practiced both here in Hong Kong and I was in Beijing for a long time as well. And the same issues arise in lots of these disputes. So you'll see differences about jurisdictional and governing law clauses. So even though you've got a global transaction, you've got multiple parties, different countries, different legal systems, you need to settle in advance what law will govern these transactions. If you don't do that, then you face a myriad of issues later on down the line. For example, I'm in a dispute at the moment. I'm acting for a Chinese bank. It's not to do with digital trade, but there are questions about what the governing law of this instrument is that governs the transaction between the parties. And there are parallel proceedings in Taiwan in China and here in Sydney in Australia. And so parties are fighting that on multiple fronts. It's expensive, it's time consuming. We got a result here in the Australian courts, but that result and that judgment is currently being stayed, so it's not being enforced. So basically the party can't get the money as a result of that judgment, because there's things in China that if whatever happens here in Australia will affect what happens in China. And so the judge here in Australia said, I can't enforce that judgment. We're going to have to wait to see what happens in China. And that could be, I mean, this has already been a few years. So it's not a satisfactory outcome for anybody who's seeking to resolve these disputes and move on. So you need to really think about governing law issues. What is the best place to hear these disputes? And it really depends on who you are and who you're representing and who your counterparty is. So will you get a fair hearing in a different country? Are there restrictions about witnesses? Chinese witnesses cannot give evidence here in Australia by video link. So they can't sign affidavits in China. They have to cross the border over to Hong Kong to be able to do that, or somewhere else. And so, you know, that's a very real issue if you're trying to prove certain things about your case. And so questions become, well, can online dispute resolution and can technology help with those issues? There's a lot of, we've acted for big tech giants before, the usual names that you'd expect. There's a lot of questions about clauses that they put in contracts with consumers. So terms and conditions, everybody ticks that. And all of a sudden, you've just signed yourself up to a dispute in the courts of Santa Clara in California. And so that's a very real issue if you've got some question or you've got something you need to be resolved, because you might not have the means or money or ability to be able to go to California to argue this case. And there's been questions in the Australian courts about whether those types of clauses are enforceable. And now there's an unfair contracts regime here in Australia where there's questions about, you know, whether or not these big corporates can enforce those types of clauses against consumers at large who don't even know, that they're signing up to them, and don't know even where Santa Clara, California might be. So I think these things people are still getting used to, and corporations are getting used to in the digital age, and how to sort of navigate them. And so you know, I think it's important to think about these up front, and we always do say that to clients, etc. But it's not always as easy. We also do a lot of work for Chinese clients who are seeking to enforce Chinese judgments here in Australia. So the other thing to think about is it's all good and well in going through this dispute resolution process, going through the courts either here or in China, and coming up with a judgment if you can't get the money at the end of the day. So we're seeing increasingly a lot of Chinese clients coming here to Australia seeking to enforce against property in Victoria or Tasmania or something because they can't get their hands on money in China. And so that raises other issues about, you know, is it enforceable? Can you take a Chinese judgment and come to the Australian courts here and seek to get it enforced here? And how do you do that? How easy is that process? Which lends itself then to arbitration as being a more attractive option for cross-border disputes, because you can take international arbitration awards and get them enforced in, Kiran probably knows the number, but like 180 countries about now, where they've signed up to the New York Convention, and you can basically get them enforced as a court judgment. So that's a much more straightforward way to avoid some of those enforcement issues. In terms of online digital technology and online digital disputes, generative AI and blockchain are currently being utilised quite a lot in some of these disputes, and I'm just going to touch on how effective and helpful they've been, in particular in Australia. So online dispute resolution mechanisms is basically where you hold the whole dispute resolution process largely online. So you don't have to go to a court, you don't have to go to a hearing room. You can all get online and you can resolve it in a way if you have the right rules and processes in place. And so obviously during COVID, a lot of hearings became virtual, which is basically online. because of the fact that nobody could move. The Australian courts also did that, and so, but they have reverted largely back to in-person hearings, etc. Arbitration, as Lu Fei mentioned, from a CIETAC perspective, and I'm sure we'll hear more from an AKICA perspective shortly, has been able to maintain those types of online processes. So you can effectively have a hearing, you can have witnesses in different time zones, simultaneous translation for people who don't speak whatever language it is in the hearing, and you can have arbitrators or judges sitting, in a number of different places at the same time, which is obviously efficient, cheaper, and better for the planet. But these online dispute resolution systems, a lot of corporates have them themselves. eBay, I think, resolves more than something like 60 million disputes annually through their own online platform. And so obviously with the rise of e-commerce and et cetera, these types of arrangements are becoming much more attractive because, you're dealing with global parties across borders, et cetera. Australia is starting to deploy these types of processes, in particular through the courts, but they're not sort of mainstream yet. I think there's a couple of jurisdictions like British Columbia in Canada, and in the UK, they're also investing huge amounts of money in trying to sort of online justice solutions and things like that. But they're still a little bit down the track here in Australia. You can still file things online and all that sort of thing, but they're not at the stage of really having a full-blown hearing online yet. But obviously, there's things like e-discovery when you have to produce all the documents. There are electronic courtrooms. There's real-time transcription of hearings, et cetera, and video links, et cetera. But we don't have full-scale services for online dispute resolution yet. AI and blockchain are also being used quite a lot. So a few examples, there's obviously automated case management where platforms just generate scheduling or document management and communications between parties. There's chatbots and virtual assistants that can help you with questions about that and provide information about the process, etc. There's also data and decision support, which is basically where you can get AI algorithms to analyze large volumes of data related to previous disputes and basically give you kind of predictions about outcomes and parties and mediators, etc. And they can help parties understand potential outcomes and evaluate their own position and make decisions during negotiations. There's also these natural language processing techniques which allow AI systems to analyze written or spoken language and interpret the content of dispute-related communications, and again, kind of categorize sentiment and analysis of witnesses and key issues. One of them is called Smart Settle, and it basically uses algorithms to generate options for resolution, and it kind of acts as basically a sort of online mediator. So you don't have a mediator per se in person. If anyone's ever been in a mediation, typically you have the mediator who sits there and then the parties in different rooms, or they come together and there's a lot of sideline chats, and the mediator kind of manages that process and tries to kind of give the parties some guidance around potential settlement or options or negotiations, etc. So in this particular circumstance, the online program does it for you. And so it generates suggestions based on party preferences and any concessions parties might want to make, and then try to get the parties to reach a solution. Blockchain, again, really interestingly, there was a woman who spoke at an AKICA conference a few years ago about blockchain technology. Yeah, thanks. How to use blockchain to your advantage in these types of smart contracts, etc. So there's off-chain dispute resolution, where basically you'd have a dispute resolution embedded within the code of a smart contract, but proceedings take place in real life as they would normally. There's also on-chain dispute resolution, where the resolution of disputes involves assets that are owned on the blockchain or in the metaverse or something like that, and they used a sort of decentralized justice platform. on the blockchain, and that's currently being developed and offered by a few decentralized justice platforms such as Aragon and Code Legit, if anyone's aware of those. And they basically use blockchain technology to decentralize the dispute resolution process, and they kind of crowdsource the adjudication of the disputes to a pool of willing decision makers who take on the kind of role of as a juror or as an arbitrator. I think there's a few advantages to that type of process, even though it might sound uncomfortable to give your dispute or the decision making over to that type of a process. But there's a lot of, so what happens in some of these is that they're basically automatic. So the decisions of the jurors or the arbitrators are implemented automatically by the operation of the sort of self-executable smart contract. And that means that any code embedded in the smart contract runs automatically to execute the decision that is rendered at the end of the process. So what I said before is it's really difficult to enforce judgments and decisions cross-border. In this circumstance, you don't have any problems with that because the smart contract just immediately executes it. So, for example, as soon as the decision's rendered, they may say, you've got 3 days to transfer the funds, or it'll just automatically transfer the funds to the address of the successful party. It might give them an extra week to do something like finish a website or whatever it is that they're required to do. And so it's pretty immediate in that circumstance. A big criticism of dispute resolution generally is it takes too long, it's too expensive, and you can't enforce it. So this the speed and the automatic kind of enforcement of this is a really big advantage to that. I guess the disadvantages to that is that you might not get any reasons for the decisions, and so there's nothing to sort of appeal necessarily, or you've kind of got to be satisfied or basically just take the decision at face value, I think, in a lot of these things. So lack of reasoned decisions, and it's unclear where this process sits in terms of having a kind of judicial or legal place of that process. So in arbitration, there's always, and the courts, there's always a place where you are hearing that dispute, and the laws of that place will help govern questions about document production or witnesses or process. In this circumstance, it's unclear where the sort of legal place of that dispute would be, and that could also raise questions about enforceability and how that works later on. So there's lots of questions, obviously huge potential as well, and we'll see more of it. I'm conscious of time, so I might just say quickly, just in respect of digital trade more between Australia and China, Australia has been seeking to, use its influence in the WTO and in FTA negotiations to try and get more commitments to ensure that online e-commerce and digital transactions are treated the same as they would with physical commerce and physical transactions. So they've used their influence that way to try and get some more uniformity in terms of rules, and particularly trade rules, etc. I guess, big questions about data flow, privacy, all that sort of thing. But there has been, in January 2019, there was Australia joined 75 other WTO members. They were launching negotiations on trade-related aspects of e-commerce, and they were representing about 90% of world trade. And I think Australia sort of is really invested in trying to get some uniformity around the rules that will govern those disputes, etc. I think the challenge is how to get all the benefits of these sort of digital trade and technology without losing the legal protections. And so that's sort of something that I think probably needs still a little bit more work.
Thank you so much, Edwina, for such a fascinating overview of the different use of technology, AI, blockchain, smart contract, and how this serve to improve efficiency and access to justice. But potentially there's also challenges, and the decentralization process also just challenges the very idea of justice. So I'm sure we'll have a lot of discussion on that later. And now I would like to move to the institutional perspective. So moving on to our next speaker, Ms. Kiran Sanghera, who is the Deputy Secretary General of ACICA, Australian Centre for International Commercial Arbitration. And Kiran supports the Secretary General and ACICA board with a particular focus on business development, bringing her over a decade of institutional experience. And she was previously the special counsel at HKIC, and she led the HKIC domain name dispute resolution team, which I can testify how efficient the team was as their domain name panelist. And she has led very successfully the team and oversaw HKIC's business development initiatives. She has also previously worked with HKIC's arbitration team as a legal counsel, handling arbitration involving parties across Asia, Europe, and Americas. So she will share with us navigating challenges and strategies for resolving cross-border digital trade dispute.
Thank you very much. Am I able to? Yeah, perfect. Firstly, good afternoon, and we've got the last session, and I'm the last but one speaker, so hopefully I'm able to keep your attention before I hand over to Pui-ki. Thank you very much, Professor, for the invitation. As Professor Fan mentioned, we met actually in the context of my work at the HKIC as responsible for the domain name dispute resolution team, and we've heard already from Lu Fei about the relevance of that area for online disputes. I spent over 10 years in Hong Kong at HKIC with various hats, and I'm, I think, probably the newbie to Australia and to Sydney, joining ACICA about half a year ago now. So it was really wonderful to be invited to bring kind of the two experiences together in the best way. Hopefully I can. What I plan to do, and I will probably whistle through some of these points because some of the elements have been picked up by previous speakers. And thank you to Edwina for the overview of Australia. I think I took a lot from that, so that was very helpful. I'll give a brief introduction to ACICA, primarily because it will give some context to the rest of the comments that I'll make, and it may be helpful for those who aren't familiar with the institution. And then a very quick slide just talking about why dispute resolution is important, with a focus on arbitration, picking up on some of the points Edwina made, and then really just spend a few more minutes there talking about the role of an institution in this setting. And that's the experience that I have at both HKIC and ACICA. What do institutions add to resolving cross-border disputes, and in this context, in relation to digital trade? So ACICA, the Australian Centre for International Commercial Arbitration, we've been around for some time, since 1985, and I would probably say, like other institutions, established, and institutions are usually ready to respond to developments in the market. And I think the latest one in terms of going online for dispute resolution is one that certainly ACICA has introduced measures to respond to, as do other institutions. Importantly, it's independent and non-profit. The important part is the independent part, and I think that's increasingly very relevant for discussions in terms of cross-border disputes. Core objective: promote and facilitate resolution of commercial disputes, including those arising out of digital trade relationships throughout Australia and internationally. A few different services are offered. Arbitration and mediation, fully administered, which effectively means the institution's involved throughout the process, and I'll talk about why that's helpful later. But also an important role as an appointing authority of the decision makers, for example, as arbitrators. And the Centre has a very unique and special role under the International Arbitration Act here to be the default appointing authority where parties are unable to make the appointment through whichever mechanism they may have agreed to, or in the event that they haven't, and it's the legal place of the arbitration is in Australia, then ACICA can take that role. So it demonstrates the level of trust in the organisation. There's an active board, that's the leadership, and Edwina has been very actively involved with the organisation over the years, so you can see the calibre of individual involved with the work that's done there. And they're also involved, certain members of the board, in decision-making in relation to cases. In terms of ACICA's experience, traditionally, Australia and its expertise has been in construction and infrastructure and energy and resources, and that continues to be the case. However, sale of goods is also a relevant area, and as Lu Fei mentioned, I imagine also many of those disputes are in the context of digital trade, so we're seeing those too. An institution that kind of packs a punch and probably above its weight tend to handle fairly complex, high-value disputes, but the rules can accommodate all different levels and types of disputes that arise. International caseload. So about 70% of the cases last year involved at least one non-Australian party, and mainland Chinese parties do feature in the list of parties by nationality that feature in the caseload. So it's clearly an important relationship between mainland China and Australia, and seeking out the appropriate forum for resolving that dispute. This has been touched on, but why? I suppose I don't know the extent to which the room is involved in dispute resolution as their bread and butter, but really, why should you be considering dispute resolution when conducting cross-border digital trade? It's really part of the landscape. So if you're conducting trade, be it digital or otherwise, or commercial business on an international level, then you really do need to think about your dispute resolution mechanism. And I won't go into this too much further, as Edwina outlined the risks of not doing so, less certainty and potential for delays in ultimately resolving your dispute. But it also, at a wider level, does support trade relationships. If you know if issues arise, they can be resolved efficiently and fairly. That supports you engaging in commercial trade globally, and arbitration certainly does do that, probably for three key reasons in the context of the discussion today. I touched on by Edwina, and it's 160. I just looked it up before we came, but it's probably soon to be close to 180. The enforceability of an arbitral decision in cross-border context, that's probably the biggest sell. And then the other element, the second element, I would say, is in relation to choosing your decision maker, your arbitrator. And that can be pretty critical in terms of neutrality, but actually very importantly in terms of their capability to resolve the dispute with the specific expertise that you might need. So in the context of digital trade, maybe there are some innovative digital technologies involved. It's helpful for you from an efficiency perspective to have a decision maker that's aware of the field in which the dispute arises. So that's point number two. Number three, confidentiality. This is, again, probably one of the crucial elements when it comes to arbitration. And if we're looking here at potentially sensitive IP matters in relation to digital technologies, or to the extent that data can be protected through at least the arbitration process, then these are elements that I think do speak to the value of arbitration. It's not the only option, but for my presentation and given the work that I do, I will, as I said, narrow in on the role that an institution can play with respect to arbitration. So how do institutions support the resolution of cross-border digital trade disputes? What do we do, and what do we do to support the process? Why do you potentially need us, or should you think about using an institution like ACICA? In essence, you get a predictable process. The procedure is supervised, and a significant amount of administrative support is provided by the institution, which is effectively an experienced guiding pair of hands and provides a very useful safety net. There are three areas that a user sort of engages with when it comes to an institution, and I've defined them as features. Starting off with the rules. Each institution will have a set of rules throughout which the procedure will be managed. ACICA does. You can see they're listed there. There's two sets, the administered arbitration rules and the expedited arbitration rules, and they effectively govern the procedure. As I said earlier, the rules suit a wide variety of disputes, and if your dispute happens to be smaller and or less complex, then the expedited rules might be the more suitable option. What do the rules give you? How do they help? Well, they make sure that you have commenced your arbitration properly. And without that, it makes it very difficult to proceed. Or if you do proceed not initiating correctly, that can certainly pose problems for enforcement of the award down the line. So that you file your notice, making sure that ACICA has jurisdiction at least at a prima facie level, and that all other parties have been served. Core function, the appointment of arbitrators. The rules will have a process which will be followed for the fair and effective appointment of arbitrators. This is the piece you really want to get right to avoid challenge to the arbitrator or, in fact, the award further down the line. Time limits, they're in there, they're in the rules, they're tried and tested to keep things moving. And also some certainty around the costs. There'll be a schedule of fees, there'll be times when deposits are provided, et cetera, et cetera. Big decision, but the freedom to choose the seat, language, representation, and arbitrator. This is found within the rules and really an important part of the process. I touched on confidentiality. It's embedded in the ACICA rules. In terms of the Secretariat, that's people like myself and Pui-ki for eBRAM. We would be the ones at some level, perhaps slightly high, perhaps less for you as you head the organisation, but you'd be in touch with in terms of the process. So you have a contact point to help guide where necessary. And then the decision-making bodies, very important to be aware of who they are and what decisions they will make throughout your process. As I mentioned, the ACICA board is responsible for certain decisions on a case, for example, appointment of arbitrators where needed, determining costs, and there are other bodies such as the ACICA Council that have responsibility for other procedural decisions that the institution is empowered to make. So be aware of who are those decision-making bodies when you're thinking about the institution you might be selecting for your dispute resolution clause. Looking at some of the functions, and this is my last but one slide. So as I said, this is very much a whistle-stop tour given the time of the day and the time remaining on the panel. But what are the key functions? Oversight of the procedure. So I've mentioned that that's embedded in the rules in terms of time limits and in terms of ensuring that filing is done correctly, for example. But again, this links now to point 3. Without prudent oversight of the procedure, there may be outcomes that may impact the enforceability of the award, even before you get to the other issues that Edwina mentioned. So at the most basic level, an institution will do its very best to make sure all the procedural steps have been met, which will reduce the likelihood of challenge further down the line. Appointment of decision makers. Again, this is really a key feature and where I think an institution can add some significant, some further significant value. Identifying arbitrators with significant and requisite experience. First point to note, certainly at ACICA, it's not always our position to make the appointment. The parties, in fact, have the opportunity to do so. It's only where the mechanisms by which the parties can appoint fail that the institution will step in. So we look for individuals with the right expertise. And I explained earlier in the context of technology why that can be valuable. Arbitrator costs, and I think this is important. An institution can sometimes do things that perhaps the parties or the other users don't necessarily feel comfortable with when it comes to negotiating fees of an arbitrator prior to appointment. We will look at the overall value of the dispute and see if the fees proposed are commensurate with that. And we're able to have a conversation prior to making the appointment of that individual whether that fee is appropriate. And I think that's a very valuable add that institutions can do. Okay. And then ensuring independence and availability. That's also crucial. And that's a process that ACICA undertakes prior to appointment. If there are any questions about independence, you want them cleared up before the arbitrator is appointed to avoid challenge later on. Financial management, again, this is quite a valuable step to ensure that funds are available so that when an award is rendered or a decision is made, that can be released promptly without delay, provided sufficient funds are in place. The last point, and this was touched on by Lu Fei, and this is when it comes to the use of electronic case management tools. So as was mentioned, and is the same under ACICA rules, paperless filings are welcomed, encouraged, certainly permitted. Electronic signatures for decisions and awards are permitted, but I would just say it will be a question for the parties in the tribunal as to whether it's appropriate to use electronic signatures, depending on whether the jurisdiction in which an award will be potentially enforced. So it's permitted, but it's important for a party to be aware of the consequence of an electronic signature versus physical, if it could have an impact on how easily enforceable that award might be in any given jurisdiction. Virtual hearings, that's a part of our lives today and permitted under the rules. And then ACICA Connect, that's the online case management platform that effectively brings everything together on secure online repository. Communications are done through ACICA Connect. It was introduced January this year, and effectively can track dates. All your documents are there. Everything to do with your case is in this online portal. So like others, and I'm sure Pui-ki will speak to eBRAM's case management tools also, this is something that institutions are doing in response to the way the world is headed. I had a little video, but I'll skip it in the interest of time.
Thank you so much, Kiran, for such insight into ACICA's approach to resolving cross-border digital trade. And I think that underscores also the critical role of institutions to adapt to the evolving landscape of dispute resolution. And with that, we'll move to our last speaker, Ms Pui-ki Emmanuelle Ta. And she is the CEO of the eBRAM International Online Dispute Resolution Center Limited, with over 15 years of experience in international arbitration and case management. She has supervised hundreds of arbitration cases and in a wide range of jurisdiction and sectors. So we also had the pleasure to work together at the Secretariat ICC in Paris over a decade ago, and she was also one of the founding members of ICC's first overseas case management team in Hong Kong back in 2008 or so. And so she has acted as a counsel of the Secretariat ICC Asian office in Hong Kong from 2016 to 21, was also appointed as a vice president of the Asian Pacific Regional Arbitration Group from 2016 to 2019. And we're very glad that she is here with us to present to us this, new development from the perspective of eBRAM.
Thank you very much, Kun. So as we all know, the evolving digital landscape is impacting on global supply chains, including those between Australia and China. Supply chains can now be faster, larger, but also end up likely more complex than before, just because technology now enables such greater complexity. And in considering all of this, dispute resolution is not usually something that comes to the forefront, despite its importance in supporting all of the supply chain activities behind the scenes. Dispute resolution serves as an important foundation for confidence when building business relationships over these supply chains. Parties need to know that the deals that they have made and the contracts they have signed are effective and enforceable. So when it comes to ensuring effectiveness and enforceability for dispute resolution mechanism across borders and different jurisdictions, international arbitration and international mediation are the usual options, because using this mechanism means that the parties are not tied down to only having the option to litigate any matter in either their own courts or the counterparties' courts. Instead, with international arbitration or international mediation, parties are free to choose a third jurisdiction, which will serve as the seat of the arbitration or the venue of the proceedings for the mediations. The law of this third jurisdiction and the court supervision over the arbitration or mediation regimes will in part determine the enforceability of the outcome arising from arbitration or mediation. While for arbitration, the seat of arbitration governs the procedural aspects. The governing law of the substantive contract governs how the contract itself is construed. It will not be surprising to say that how the contract itself is construed will have an impact on the merits of a party's case. And as mentioned by Edwina earlier, it is therefore quite critical that the appropriate governing law is selected, in addition to selecting an appropriate seat of the arbitration. So for parties who do wisely pay attention to the seat of arbitration, the challenging question often then becomes which jurisdiction should be chosen for the seat of arbitration, and which institutional rules should I select for the conduct and administration of any arbitral proceedings, and specify such institution in the dispute resolution clause of the contract. The answer to these questions will always depend on the specific transaction at hand, but it is safe to say that for trades between Australia and China, Hong Kong as a seat may be a good option, and I will further explain why Hong Kong should be considered in the next slide. There's also the question of which institutional rules among all of those available around the world should I choose to administer the arbitral proceedings when a dispute arises. Again, a Hong Kong-based institution to administer the arbitration proceedings seems to be another good option. So as an institution based in Hong Kong, eBRAM International Online Dispute Resolution Center offers online dispute resolution services, in particular the eBRAM APEC rules, which by default provides for Hong Kong as the seat. This works well with the fact that as a qualified institution in Hong Kong, parties with arbitrations that are seated in Hong Kong and administered by eBRAM as a qualified institution are eligible to apply to the mainland Chinese courts for interim relief against mainland Chinese counterparties with the assistance of eBRAM under the interim measures on arrangement signed between the courts of the mainland and Hong Kong. Hong Kong-seated arbitrations also benefit from the arrangement concerning mutual enforcement of arbitral awards between the mainland and the Hong Kong SAR. So awards rendered with the seat in Hong Kong can be enforced against assets based in mainland China through this mechanism. The parties would, of course, be required to specify the governing law of their contract on their own accord. And if they wish to select a seat that is different from the default seat, they can also do that in their dispute resolution clause. However, the interim measures arrangement between China and Hong Kong only applies to arbitration seated in Hong Kong and administered by one of the 7 qualified institutions as listed by the mainland courts in Hong Kong. So eBRAM is an arbitration and mediation institution and a law-tech ODR company that has developed an online dispute resolution system, or ODR system, under which there are a number of rules designed to cater to different needs. And one set of rules that I would like to recommend, and that has already been mentioned by Lu Fei earlier, for use, one set of rules for resolving cross-border transactions would be the APEC rules. Despite its name, the APEC rules are not limited in scope to the APEC economies only. The eBRAM APEC rules are only named as such because it was developed on the model procedural rules under the APEC collaborative framework for ODR, for cross-border business-to-business disputes, which in turn is based on the model procedural rules as set out in the unsecured technical notes on ODR. Also, eBRAM is globally listed as one of only 5 ODR providers providing ODR services under this APEC framework. These rules are also available to cover all types of disputes, including cross-border business-to-business disputes, and the default seat, again, is in Hong Kong, but the parties can opt out of Hong Kong and choose another seat. And to further assist the parties and control costs associated with dispute resolution, the initiative and filing fees of the eBRAM APEC rules charged by eBRAM as an institution were also set to cater to small and medium-sized enterprises, allowing them not to be priced out of dispute resolution due to high cost. We understand that for there to be comfort in trading cross-border, there needs to be confidence that there is a realistic and workable dispute resolution mechanism underlying the transaction, and eBRAM aims to provide this. Now, a few words about the mechanism under the eBRAM APEC rules. It is a multi-tiered dispute resolution that combines negotiation first online, then online mediation, and arbitration under one set of rules. This means that companies only need to refer to one set of rules in their contract dispute resolution clause, and there is no need to build a custom multi-stage dispute resolution clause, which may be at risk of bad drafting, resulting in the clause failing to operate when most needed. And to help with this, eBRAM offers a model dispute resolution clause on its website, which parties can simply copy and paste into their contracts. The APEC rules mechanism is well suited for modern digital trade disputes because it offers an expedited process such that if a dispute is not resolved in one of the earlier stages, the parties can quickly move into the next and final stage, that is arbitration, to reach a determinative arbitration stage if the parties are unable to reach consensus through negotiation or mediation. The eBRAM APEC rules provides for very short and aggressive time limits for each stage of the proceedings, 10 days for negotiation that can be extended if necessary for another 10 days. If the parties cannot reach consensus by negotiation, eBRAM will appoint a neutral to act as a mediator for 10 days. And if, again, the mediation stage fails, then the parties will be required to go to the final stage, that is arbitration. So any disputes conducted under the eBRAM APEC rules may be resolved in less than 1 to 2 months. The process can be expedited also because the neutral who acts as the mediator during the mediation stage will also serve as the arbitrator during the arbitration stage, which means that there is no need for the neutral to spend extra time to familiarize him or herself with the facts or the legal issues of the case. So the expedited nature of the dispute resolution process under the eBRAM APEC rules reflect the expedited nature of modern digital trade business transactions. If you are interested in learning more about the APEC rules, I have hard copies available, so come to me after the session. So I'd like to give you a quick overview of and walkthrough of our ODR platform so that you understand what we mean by ODR. So the eBRAM APEC rules that I've just mentioned earlier are also supported by a digital one-stop platform, and that is called the eBRAM Online Dispute Resolution or ODR platform. That platform complements the eBRAM APEC rules and modern digital transactions by enabling the entire dispute resolution process to be conducted online if necessary. This means that users will be able to submit their claims directly online. The response from the counterparty, the proceedings, the communications with the neutral will all be conducted online as well. And there are also other tools on the ODR platform to help the parties manage information related to cases and the procedural aspects. And we also have an e-signing system allowing parties to sign any mediated settlement agreement. And as like Akika, we do permit e-signing of awards, but we do encourage parties, tribunal to send us original wet ink signed of awards for enforcement purposes. However, if the parties and tribunal agree to that electronic signatures can be used, we are happy just to provide that to the parties. And of course, the tribunal members can make use of the e-signing system through the ODR platform. So this is particularly useful. I think all these tools and this one-stop platform for cross-border disputes where parties are often physically located in different locations like Australia and China. And if the parties come to a stage when they need to meet for a mediation session or for the arbitral hearing or for a case management conference, they can use a video conferencing system that has been integrated into the ODR platform. And we have also a machine real-time transcription that has been integrated into the video conferencing system that we have developed. Transcription is a common facility that is very often used or even required by the arbitrator. to make sure that there is a record of the arbitral hearing. And human court reporters providing transcription services can be quite expensive and may not be available on demand. So with the inclusion of the machine real-time transcription feature into the ODR platform video conferencing system, costs can be further reduced and the transcription functions can be available on demand. And to give you a quick feel of this, I have prepared a video recording to show you how the machine transcription works. This is a case where the parties chose to use our platform to conduct their hearing.
My name is Mei Tai, and I have been appointed by eBRAM to serve as a neutral arbitrator to hear and decide this matter. I, not eBRAM, will decide the award. Could the parties or their representatives please introduce themselves?
Yes, thank you. My name is Robert Roeder, and I represent the claimant in these proceedings.
And my name is Friven Yo, and I represent the respondent.
Yeah, so this is done by the AI tool that we have developed, and the transcription is made available right after the end of the meeting. You can simply click the export button. You have a Word version of the transcription. If the lawyers and the parties, the arbitrators do not have trust in the system, we're happy to also provide polishing by human case managers during the hearing. So apart from this, we also have a document this is the slide I wanted to show you. So once the document has been exchanged, uploaded onto the system, the other side can either download a copy or also perform translation if translation is needed. We have currently 15 languages available, including English, Chinese in simplified and traditional forms. We have Arabic, Russian, Spanish, and French, etc. So these tools are made available for the parties and the arbitrators to use any time during the proceedings, and we're not charging any extra costs for use of the system, since when parties have agreed to use our institutional rules and refer the cases to eBRAM, they get the institutional services plus the ODR platform. So and I'd just like to conclude by saying that the simplest action that can be taken to generally protect the parties' respective positions is to include a dispute resolution clause that specifies the use of an effective and efficient set of rules. And I think this is a use case where the eBRAM APEC rules can be really helpful for Australian and Chinese businesses. And I hope that the solution presented today will help with navigating the challenges and resolving cross-border digital trade disputes. Thank you.
Thank you so much, Pui-ki, for that overview and for showing how it was very impressive how this automated transcript have been doing. I know that you can automatically translate it also in different languages.
Yeah, that's right. I forgot to mention that we even have a machine translation for the transcription. So we have not prepared a recording yet, but what you could do is having the transcription plus translation into Chinese or English or vice versa. We do that as well.
Thank you. Thank you so much for all speakers for this insightful sharing. So we'll have time for a few quick probably questions. I'll first see if we have any questions from the audience. Yes.
Thank you very much for the very informative sharing. My name is Li Zhang. I'm a Chinese lawyer, but also qualified practice in Australia. My main practice area is dispute resolution, commercial dispute resolution. I have a question about digital currency and relevant legal remedy in Australia. So, well, while the digital currency facilitate the international trading, it also make fraud a bit easier. And as a Chinese lawyer, I'm very much interested in a topic about tracing law, which is in the Australian common law or equity. If my understanding is correct, the tracing law would enable, if a property is obtained by fraud, like the tracing law would enable the original proprietor to to claim against the third party who subsequently obtained the property, or claim for the consideration paid for that property. So yeah, if the property is taken by fraud and subsequently transferred to a third party, then the original proprietor would be able to claim against that third party directly, or claim for the consideration being paid for that property. So that's I'm very impressed by that mechanism, if my understanding is correct. And in the context of the digital currency, I wonder if the same principle apply to digital currency, because it looks to me it's much more easier for the to claim for damages if the digital currency fraud happens. For example, in China, I read news last week. Then there was a fraud happened, and 500 million RMB has been transferred overseas in form of digital currency. So I just my question is about how this digital currency and the law of tracing would work interactively in Australia, and or if there is another unique tool in arsenal of common law equity, which would helpful to seek remedy in those kind of fraud contests. Thank you.
I guess that's to me because I'm the Australian representative. Super interesting question. I don't have experience in the sort of digital currency tracing aspects of the question, but happy to take it on notice. I think in terms of the fraud piece, it's funny because I've had fraud allegations in cases here and also fraud allegations in cases in China, and they do get bandied around a lot. I think the difficulty of fraud in Australia is that the bar is very high in terms of being able to prove the fraud. And I guess if you're talking about, so assume you get over that hurdle, that you can prove that there was a fraud, and then the digital currencies, as you say, get sold or whatever. I guess the tracing of that and being able to demonstrate the link between that and the fraud, I guess, is one of the challenges here. But sure, certainly, if you are able to prove here in Australia that you do have a fraud and then property, whether it's digital currency or real property or whatever it is, gets subsequently transferred, then there should be a remedy for you to seek by way of that, tracing that. Some of the difficulties we do have that we've seen with clients here is really the tracing piece, and I don't know how it works, to be honest, in terms of digital currency, but in terms of real property, for example, you've got to be really conscious of timing because, for example, someone has a transaction, they use the proceeds of that sale to do something else, and potentially we've got a case where we're trying to seek money against a judgment debtor who has, maybe 6 months ago sold a property, and then the daughter buys a property in the daughter's name, and we're trying to link the money to the daughter because it all happened very quickly, but it's really, really, really difficult to prove. And so I think the remedies piece where, you might want to get some sort of really fast interlocutory or ex parte injunction to freeze those assets, to stop them moving around. As soon as they become cash, it's just very difficult. And I know digital currency is a different beast. And there was discussion before about, traceability and transparency around crypto, for example, crypto exchange and how those get sold and who they get sold to. I guess it would depend on the traceability of that and whether or not you could seek to use those kind of extraordinary measures or remedies here, because the courts are willing here in Australia to grant ex parte injunctions where there is urgency, where they do see a risk of dissipation, etc. But in my experience of doing that here, it is very dependent on the circumstances, the urgency with which you act. So, if you're trying to freeze something but transaction happened 6 months ago, then it's really difficult to demonstrate urgency for that. So I guess the problem is as soon as you know something's happened, it may be too late. and then it's hard to kind of get your hands on the money or the asset or the currency or whatever it is. But certainly, if there hasn't been, to my knowledge, a case regarding digital currency and the fraud kind of traceability piece, but maybe that's something that will be coming, and be interesting to see how that plays out here in Australia. Sorry, I couldn't be more specific.
Thank you. If I may raise follow-up to two quick questions to our other panels. One question, I guess, is more for the institutional perspective, so for Lu Fei and Kiran. So in light of this advance of technology, what can institutional do to sort of ensure technology advances do not bias the dispute resolution process, given the different degree of access to technology of divergent disputing parties? If I could ask the panelists, please be brave.
I will be. I think that's a really important and relevant question that was discussed quite heavily during COVID, because that was really the first time, I think, for a lot of institutions that virtual hearings were having to be part of the process. And I think there are varying decisions, and depending on which jurisdiction you're in, you'll get the answer as to whether it is really something that can be implemented without causing bias to one of the parties. But I think ultimately the tech, in the same way that any other part of the procedure, that has to give the parties the opportunity to present their case. I mean, that's kind of one of the fundamentals. And if using technology, and I just go back to the virtual hearing piece, because that's what I saw a lot of at HKIC, leads to some concerns about a party being able to present its case, then I think there is a question for the tribunal as to whether that piece of technology should be used in this particular case. Was that short enough? Okay.
I wonder if Lu Fei, you want to add any comments on this?
Yeah, we are very flexible actually to adoption of technology by either party. For example, the online hearing. Well, quite often the online hearing can be in a hybrid form. That is, one party online, the other party actually coming to CIETAC, sitting in the hearing rooms. And even, when the tribunal members, they want to have like assistance by the institution in the process of the hearing, even if both parties actually are online, the tribunal member can come to CIETAC and have our assistance. So basically, it's a very flexible situation. The parties can choose whatever approach they feel comfortable with. But with the document, the submission of documents, well, the current practice after the promulgation of the new rule is that in the notice of arbitration, well, still the notice, we have hard copies, it's not electronic. We send to the parties and ask for their consent to use the electronic means. If both parties agree, then it will be in electronic means, or they could agree otherwise. So it's primarily lie in the choice of the parties.
Thank you. Thanks, Lu Fei. And another question, I think more for Pui-ki, about the ODR, since we see that ODR is becoming more prevalent, right? So I guess kind of, the predictions of what do you predict as to be the next significant evolution in the ODR practice, and how that might affect and transform the cross-border dispute resolution?
Very good question, because it is our mission as a ODR and law tech institution to find ways to improve the ADR processes and find ways to use technology to augment ADR. And we believe that we can do that through online dispute resolution. And one of the ways that we are looking ahead is to explore first AI tools, generative AI, to then develop this kind of AI tool to make them available, integrate them into our ODR platform to make them available for the parties and the arbitrators to use, not to be there to replace the arbitrators and doing the job of the arbitrator, but being just a tool to assist them. So I'm referring to tools like being able to summarize submissions submitted by the parties, uploaded onto the platform, extracting information or populating the award through the submissions filed by the parties, but not, of course, the reasoning part of the award. So we are trying to see whether we can help the tribunal, simplify their life so that they don't have to summarize the procedural background of the dispute and of the procedural aspects of the case. And so we are looking into implementing more AI tools into the system in the future.
Thank you, Pui-ki. And I think that is probably coming close to the conclusion of our panel. And I want to conclude with a quote from Mark Galanter: just as health is not found primarily in hospitals or knowledge in schools, justice is not primarily found in courtrooms. So in the age of digital economy, we should consider how technology can contribute to the broader access to justice, primarily for those also small and medium-sized enterprises in the digital trade, and what barriers that might create. And with that, I would like to really thank for our excellent speakers for sharing of those insights. And I would also like to now pass the floor to my colleague, Deborah Haley, for concluding remarks.
I'd like to thank Wood Mallesons for housing our conference. And in particular, I'd like to thank the Wood Mallesons staff, Matisse Rose and Marlon Ramones, who have been working with us all day to ensure that the conference has been delivered smoothly. And I'd like to thank the photographer, Matt Teague, and the videographer, Aaron Van Dyke and his team. Finally, I'd like to thank the CIBEL support staff, Hannah, Alice and Licia, who've been here all day working hard, and of course, Fionn Chua, who's the CIBEL Centre Manager, who has directed it all. And I'd like to thank the National Foundation for Australia-China Relations for the funding, which has made it possible. Thank you all for attending, and we hope to keep in contact with you. We have an array of research and other conferences later in the year. So please, thanks for coming, and join us outside for some further discussions and drinks. Thank you very much.